स्टूडेंट टाइप स्मार्ट काम करो, सब्सक्राइब के साथ साथ बेल आइकन भी दबाओ।
Hey guys, welcome to Manoeuvre. I'm Advocate Nisha Lotia and my today's session is for all the law aspirants who are preparing for the 2021 entrance exams. Students, whether it is CLAT, MH Law CET 3 years or 5 years, AILET, DU-LLB, SLAT or any other law entrance, these questions of tort law will be really beneficial for your preparation. I'll discuss each and every question, but before that, let me tell you about the online lectures which Manoeuvre is offering you during this pandemic. You can stay home and be safe and yet prepare yourself for the 2021 exams. Guys, we are conducting online lectures, and for the same you can call us or WhatsApp us on the number flashing on your screen, that is 8828581455, or you can visit us at manoeuvreedu.com. This is our website where you can join us, and where otherwise also you can ask any questions and that will be replied. So guys, without wasting any more time, let's get started with the law of torts, which is my personal favorite law because it is very interesting and the concept is very different from the law of contracts, or you can say the Indian Penal Code. That is what is the law of torts. It is a civil wrong, guys, where in the absence of a contract or in an absence of an intention to create an injury, yet an injury happens, then how will you approach the court of law? So you can approach them through law of torts. So it's a very, very interesting topic. Let's get started. I'll read the direction first. Each question consists of legal propositions or principles, herein referred to as the principles and facts. So guys, mostly आपको principles and facts पे questions आते हैं. These principles have to be applied to the given facts to arrive as the most reasonable conclusion. Such principles may or may not be true in the real sense. They are illusionary, imaginary, but yet you have to conclusively assume them to be true for the purposes of this section. This is the thing that is mentioned as direction. Now guys, I'll read the principle, I'll read the facts, and I'll read the options also. Thereafter, pause the video, try to solve it by yourself, and then come back to the explanation and check whether your answer was correct or incorrect. So let's get started with the first question for the day. The principle is injuria sine damnum. Now these are the legal maxims, the Latin words, okay? That is injury means violation of legal rights without damage. Now injury to what? Injury to your legal rights, okay? And sine means without, damnum means damages. Damages मतलब आपको actual में loss नहीं हुआ है. Okay, then also can you claim compensation? Yes, you can claim compensation because there has been injury to your legal right, which is very, very important in the eyes of law. Now let's get started with the facts. X, who was the returning officer at a polling booth in Amethi, wrongly refused to register a duly tendered vote of Y in the recent UP elections, even though Y was an eligible voter. Now over here you have to be careful that they have said Y was an absolute eligible voter, okay, but yet he was denied to vote. Now voting is what? Voting is your right. Now he was denied that. The candidate in whose favor Y wanted to vote was declared elected. Now actually agar aap dekha jaye, then he was supposed to vote for say Mr. A. Now when he was planning to vote for Mr. A, finally even without his voting, A was elected. Okay, so actual loss to kuch bhi nahi hua hai usko, correct? But then what has happened is his legal right has been denied. There has been injury to the legal right, correct? So he is entitled to the compensation. Okay guys, now over here the options are, the question says give the appropriate answer. The option A is Y can sue X on the ground that he was denied the right to cast vote, which is a fundamental rights, okay? B says Y can sue X on the ground that he was denied the right to cast vote, which is a legal right, okay? So between A and B, if you have a choice, then it is a fundamental right and the legal right. Y cannot sue X because there is no injury or damage caused to Y. and Y cannot sue X because the candidate in whose favor he wanted to vote was declared elected. Now this is a suggestion. So I told you in my last contract video also, suggestion will never be your legal answer. So D option is तो आपका आंसर कभी हो ही नहीं सकता. Now Y cannot sue because there is no injury or damage caused to Y. Now this cannot be your legal answer. Okay, so that is also not your answer, because the principle says if there is a injury to your legal rights, you have a right to claim compensation. Okay, so you know, Y can sue X, but on what grounds? Okay, is voting a fundamental right or is voting a legal right? So guys, you have to be aware about this. Voting is not your fundamental right, voting is your legal right. In this case, the maxim is injuria sine damnum, okay, which means if there's an injury to your legal right, you are, you know, allowed to claim compensation. So over here, you can sue Mr. Y can sue X on the grounds of the legal rights, okay, not on the grounds of the fundamental rights. There is another maxim, that is damnum sine injuria, that is also very important. Please go through that also. Okay, now going on to ahead with the next question, guys. The principle says vicarious liability is the liability of the master or principal for the tort committed by his servant or agent, provided the tort is committed in the course of employment. Very, very important is the course of employment. The master or principal is not liable for the private wrongs of the servants and agent. Of course, now if you hire a driver, say if you hire a driver and he has a duty from say 10 to 7 with you, okay, so before 10 and after 7, if he is doing any personal wrongs, will you be held liable? No, you cannot be held liable, correct? Because that was not during the course of the employment. Okay, so you have to understand in real sense what does the course of employment actually mean by. Okay, so facts of the case goes, X hands over some cash money at his house to Y, okay, at his house to Y, who is X's neighbor and is also cashier in a bank, to be deposited in A's account in the bank. Instead of depositing the money, Y misappropriates it. Now what does the word misappropriates it? Means he utilizes for his own self. Okay, so that is he's not depositing it in the bank, but he is using it for his own purpose. Okay, so which of the following statement depicts correct legal proposition in the given situation? Now over here in this option, you have to be careful whether the condition what they have mentioned in the principle is about the course of employment, whether that has been applied or not. The bank would not be liable because Y did not do any wrong in the course of his employment, correct? The bank would be vicariously liable because Y was the employee of the bank. The bank would not be liable because Y did not do any wrong. The bank would be liable because Y acted as bank's agent. Now the C option, which tells me the bank would not be liable because Y did not do any wrong, ये तो कुछ मतलब ही नहीं बनता है ना. Of course Y did something wrong, correct? But can it be bank, this type of a legal suggestion will never be our answer, okay, because it is not having a legal language in it. Very, very important is a legal language. A suggestion will never ever be our answer. Okay, now for the first, let me tell you about the facts. The principle says that it has to be during the course of employment, correct? The course of employment is very important. X hands over some cash at his bank to Y. Okay, where did he give him? He gave him at his house. Now when they are doing some private personal transaction which is inside the house, how can a bank be held liable? Okay, because it was not during the course of employment. Had he gone to the bank and had he given Mr. Y the money, then there would be another issue, but not over here because he is giving him it at his place. Okay, so the bank will not be liable, guys. You have to understand, because it is not during the course of employment. As I told you, the example of driver, what driver does before 10 o'clock and after 7 p.m. in the evening is not the the master's purview, correct? The same way over here, if they are giving anything in the personal capacity, how can bank be held liable? The bank would not be held liable because Y did not do any wrong in the course of his employment. Okay, this is a very, very important. See, this is giving me the legal answer. The bank would be vicariously liable because Y was the employee of the bank. Y was the employee of the bank, but the act has not happened during the course of the employment, so the bank will not be held liable. okay, the bank would be liable because why acted as bank's agent. No, ये तो कुछ principle में से agent वगैरह का mention ही नहीं है. So this will never be our correct answer choice. You have to strictly follow the principle mentioned. Okay, I explained you in my last contract video also. Strictly follow the principle mentioned. Okay, so A is my correct answer choice over here. Moving ahead with the next one. A person has no legal remedy for an injury caused by an act to which he consented himself. Okay, which he is consented, guys. What does this mean? This means voluntary non-fit injuria. If you are, permitting for any wrongs and afterward if वो wrong होता है, then you cannot claim compensation for the same. For example, I will tell you, अगर आप car racing में, Mr. A and B are participating in a car race, okay? So what happens कि B के stand में A आ जाता है and whereby the car gets, clashed and there is an accident. Can the parties sue each other? They cannot sue because when they are participating in a car race, ऐसे type के incidents होते हैं, correct? So whenever you are consenting in the sense when you are permitting, so later on you cannot, claim for the same. The facts of the case goes, are a cricket enthusiast purchases a ticket to watch T20 match organized by the Indian Premier League, that is your IPL. During the match, a ball struck for 6 hits R on his body and injures him. He sues IPL for compensation for the medical expenses. Which of the following derivation is correct? Now this is the direct application. When you are purchasing a ticket for IPL, you permit for such injuries, you permit for such risk. Now, which of the following derivations is correct? Guys, pause the video as I read the options and then come back to the answers, okay? Now, the first option goes, R should be compensated as he purchased the ticket to get entertainment and not to get injured. Now, इसमें में मेरे को कोई भी legal language नहीं दिख रहा है, okay? So, I'll not, go for this answer correct. R would fail in his action as he voluntarily exposed him to the risk. IPL would be liable as it did not ensure that the spectators were protected from the risk of such injuries. Now this kind of answer is also not my answer, none of the above. R would fail in his action as he himself exposed to these risks is my correct answer choice, because once you're consenting, guys, once you're buying a ticket, once you're consenting, you are yourself permitting, okay? So it is voluntary non-fit injuria, voluntary non-fit injuria. You have to be very, very, well versed with these languages and these maxims. They are short questions, I'm telling you. They are the short questions when it comes to tort law. Tort law is the second important, topic after the Contract Act. So guys, it is very easy also. There's a very limited portion. I would request everybody to go through the syllabus properly, understand the types of question, and legal aptitude, once again I'm telling you, it's very, very scoring. Okay, the next question is, ignorance of law excuses no one. In the sense, if you do not know any law and you are in a trap, then you cannot, plea for excuse. In the sense, for example, I will tell you, if there was if you cannot park your, say a car in a particular area, now you have parked your car there, okay, and then when the police comes and they say, okay, you're not allowed to park your car, then you say, oh, I'm not aware. Does the police actually listen to you? He does not. Why? Because ignorance of law excuses no one. If it is a law, it is a duty of the citizens that you should know the law, okay? So this is what it is trying to tell you. Now these are also again based on, the maxims. So it is very important. Tort law में बहुत से maxims है. It is very important that you understand them in the correct sense. Then examination में आपका बहुत fast हो जाएगा. मतलब the reading time and the understanding time will really be very less. Okay. So let's see the facts. X fails to file his income tax returns for a considerable number of years. The income tax department serves upon him a show cause notice as to why proceedings should be initiated against him for recovery of the income tax due from him with interest and penalty. Which of the following derivations is correct? X may defend himself by taking the plea that his legal advisor had not advised him to file the return. X would have to pay the due as ignorance of law and failure to comply with law is no legal ground of defense. X may defend himself successfully by taking the plea that he was unaware of any such law being in force. Now if he is saying I was not aware that I have to pay my IT returns, will the court, if you are there in front of the tribunal, okay, in front of the DRT tribunal, if you are there and they are telling you that you have to pay, then he's saying I am not aware that I have to pay, then the tribunal will say you have to pay the original amount and you have to pay with the interest and the penalty also, because it is a very well settled law of law of India that ignorance of law is no excuse. You cannot give an excuse that I was not aware or the legal advisor didn't tell me, my legal advisor. These are no excuses, okay guys. So the A option, which is telling about the legal advisor did not advise him, will not be acceptable, and that he was unaware of these things will also not be available, and none of the above. X would have to pay the due as ignorance of law and failure to comply with law is no legal ground of defense. You cannot give any defense. There is no chance of defense when it comes to ignorance of law. Okay guys, so this is very very important. Please pay due attention to it. Going ahead with the last question. Principle says in a civil action for defamation, truth of the defamation matter is an absolute defense. However, the burden of proving truth is on the defendant and he is liable if he does not successfully discharge this burden. Now, first of all, you should know what is defamation. Defamation is when you are defaming somebody. Okay, when you are defaming somebody, when you are lowering somebody's reputation, you are said to defame him. Now it is very very important that in law you have to understand what is defamation. Defamation, there are 2 to 3 ingredients which are very important to prove defamation. First of all, the defamation has to be public. Okay, this is the first criteria. And secondly, you have to prove what you are saying. In the sense, if you're blaming somebody for something wrong or you're accusing somebody, then you have to prove the same in the courts of law. If you cannot prove it, then you are in a trouble. Okay, so this is the well settled law when it comes to defamation, and it is clearly mentioned here, and he is liable if he does not successfully discharge this burden. Discharge this burden, kaun sa burden guys? To prove. Okay, ye proof karne ka. Okay, so for example, if you are saying that so X person, who might be a minister, he's taking a bribe. Okay, so you put this in a newspaper, and afterwards when that minister is suing you, and if you cannot prove the charges what you have told against him, then you are in a trouble. So defamation is always something that has to be public and it has to be proved. Okay, so let's go with the facts. D, who was the editor of a local weekly, published a series of articles mentioning that P, who was a government servant, issued false certificates, accepted bribe, adopted corrupt and illegal means to mint money, and was a chief monger. P brought a civil action against D, who could not prove the facts published by him. Okay, so he could not basically discharge this burden, correct? He will be in a trouble because he could not prove it. Okay, under the circumstances, which of the following derivations is correct? D would be liable since he could not prove the facts published by him. D would not be liable as such an action could curtail the right of expression and speech of press. Now there is no mentioning of right of expression in speech of press. No doubt this is also, there is also reasonable restriction to the same, guys. They are not the absolute rights, correct? There is a reasonable restriction to it. Okay, so this cannot be my correct answer choice. You cannot speak any ill about somebody, correct, if you have a right of expression. D would not be liable as media could publish anything. Now this is not my legal answer, so this is not my correct answer choice. None of the above. Okay, none of the above is also not my correct answer choice. D would be liable since he could not prove the facts published by him. So this is nothing but, guys, if you know what is defamation and you know how to read the principle, then this is nothing but the direct application of the principle, guys, I must say. Tort law, I'm once again repeating, tort law is very interesting and very easy. There are certain concepts which you have to understand, and I'm sure you will ace through the topic. There's nothing that is not, you can't understand when it comes to tort law. Okay, so I hope these questions are going to be really helpful, guys. Now Manoeuvre can help you with the entire online and the offline program, guys. We have the books, we have the mock test, which are the replicas, guys, of your D-Day examination. So आपको time management कैसे करना है, कौन सा section आपका weak है, कौन सा section आपको पहले attempt करना चाहिए, everything you get a clear idea when you go through the mocks, because every student का strength or weakness different रहता है. We have the sectional course also, so if you want only for legal aptitude, or you want only for quant, or you only for GK, we have such sectional course also. We have the entire course also, guys, and we have the live lectures also going on. So we have the entire package going on. So you can contact us on 8828581455, or you can visit us at manoeuvreedu.com law entrance, guys. We are located at Borivali, Dadar, VASAI, and very shortly we are coming to Pune also, guys. So guys, do subscribe the channel, and do share with your share it with your friends and relatives who will appear for the exams, because we're gonna come with so many different types of questions with the shortcut tricks, and most important questions for your examinations during this pandemic. That is what Manoeuvre can do. Okay, so guys, stay home, stay tuned, and all the best. Prep smart. Thank you.